Consent of petitioner, I beg to mention item number 14, Lordship. It is a serious matter. 13 to 16. I am appearing for item number 14, Lordship. In this case, we want to file on vacating petition.
Yes.
In this case, we want to file one interlocutory application for vacation of interim order, Lordship. Therefore, Lordship, can you adjourn the case for today and list the matter of next week, Lordship, any day?
Who is appearing for the other side?
You are for the. Lordship, there is the day, Lordship. I can order some contempt petition. Lordship, can it, service is completed. Can we come on admission hearing on 3rd of April, Lordship?
Why it has been listed for orders, madam, today?
Lordship, we want to file, it is service is not
Listed
complete.
for orders.
Orders.
Orders at
There was an, actually, there was, service was not completed in one case, Lordship. Mr. Ahmed.
Files, item number 15. 15.
Service completed.
That's the complete. Yes.
Itu পইলো level.
In two cases, there is scale also. I want that these two matters to be segregated so that these two matters is hard, otherwise revenue will be lost. And in those two matters, service is constant.
April.
What happened in those aisles?
I think they.
Service is completed.
Service is completed.
We are asking about what happened with those aisles because there are 3 aisles. What happened?
In item 15, my lord, we had filed an application for treatment IA four
That
nine
is
one,
over. The restaurant number 5 have already appeared.
item 15, my lord. We have taken steps upon the respondent through Dusty and we have filed the affidavit, my lord. Item 15.
Mr. Ahmed.
Nisar.
Which I,
IA 491, my lord.
আমার তো একটু complete হয়েছে।
INI.
Foreign interest services complete. Showing that service is complete.
you have not taken steps.
We have taken on IA 491, my lord. There is affidavit.
Just before us. Note is, office note clearly reveals that you have not taken steps. We will dismiss this.
Well,
We'll dismiss this, you have not taken steps.
we have, I'll show, my lord.
Where you have taken, steps? There is no note, show us. If you have to find out there, when the matter is before the court, you know, it has been listed. Yes, next. Yes, who is mentioning the next item?
Lordship, item number 14, list on 5th of April.
Pass this
Lordship.
order later. Let a matter reach.
May I please lordship, I don't know 9 member, I beg to manage them. I'll pass over this month for the next week. My faith as is left now is fever.
9. Nine.
Tell you one week time, my lord. And elsewhere is not received, my lord.
Elsewhere has been submitted.
We wanted to know, Ms. Verma, whether the petitioner appeared before the SP border
Appeared on 24/8, madam.
24/8.
Yes, madam. 2021.
You have the information.
Yes, madam. And elsewhere is probably submitted yesterday, madam.
Pursuant to the order dated 1/3/2024. The records, relevant records of the concert for staff number 53. I will receive by registry. Please this matter. Yes, that's a good order.
My lord, I beg to mention item number 3, my lord. My lord,
Item
humble
number?
prayer is dead, my lord. My lord, matter may be taken as first item, my lord.
Item number?
3 may be taken now, my lord. I have some personnel.
Will take up.
My lord.
Mr. Pai, it was adjourned on 11th of March on your request. Any idea why? It's a fresh motion.
Yes. Well, in the case, okay, in the meantime, opinion is passed in this case. Okay. I have the opinion. Total case, no? That's 14. Around 14, the matter has been disposed of, my lord. Last it was fixed on 14.
What's your good name?
Jai Islam.
Jai Sarkar,
Jai Islam.
Jai Islam.
Yes.
You have been shown in the call list.
Yes.
Your full name, brother?
Jahirul Islam.
Yeah.
Yeah.
What number? It has been wrongly shown as R Islam. Who is R Islam? You are J Islam, right?
Yes.
But in the first page it is shown as R Islam. That's why the record of the post also reflects R Islam, not J Islam. All for the records of case number F dot T dot within the computer GLP oblique 1356 oblique 15. Disposed of one. 10/01/2019 from the office of the Foreigners Tribunal number 3, Balpara, as well as the records of FT case number FT in bracket 6. That's 970 of the CLB of 2019. Disposed of on 14/03/2024. From the office of the Foreigners Tribunal number 6, Balpara. Let the matter for motion immediately on receipt of both the records, both the relevant records of the concerned foreign authorities. Reference is
My lord, no reference has been initiated, lordship, in this case. The voter matter.
Now, whether the ERO submitted any report or not,
Lordship,
what is the instruction of the SP board?
lordship, Dada. এই কাগজটা আপনি দিয়েছি।
Whether the SP board received any report from the ERO, any instruction in that regard?
I think lordship, ERO has sent a letter to the SP, whether any voter case has been initiated or not. Lordship. After that instruction has been sent to ERO, lordship.
So this is how, whether there is any information from the ERO. No, what about the SP could have shown, no? He could have said that whether he received any report from this regard, any request from the ERO.
Yes, Lord.
We wanted to know from the SP border, Nagaon, whether he received any such report from the ERO to initiate any proceeding or against the procedure or not. That's what is required.
Yes, lordship. Act 2, lordship, I will
That's what
clarify.
ERO has furnished any report before the SP border, Nagaon. He's supposed to refer it.
Yes.
Now, whether he received any such report or not from the ERO. State either he has received or not received.
Yes, Lord.
He has to verify from the records.
Yes, yes,
Tomorrow,
yes.
Mr. Ali will have it tomorrow.
My lord.
Place tomorrow. Enabling the Superintendent Police Border Nagaon to apprise the court as to whether the concerned electoral registration officer submitted any report before him expressing its doubt regarding the citizenship of the petitioner for necessary reference to the Foreigners Tribunal or not. If so, When did the SP Board receive such report and request from the concerned ERO?
Availers.
One to one. One to the now. One to the. One of the.
May I please, Your Lordship? Members, in this case, the petitioners was declared to furnish the post 25th March 71 members. When the notice served to the petitioner without showing any.
Yes, Mr. Sharma, where is Mr. Sharma? Mr. Payang, we have sought for the record.
Yes,
Is there any information because the order, copy of the order was given to Mr. Sharma? Mr. Sharma, earlier we furnished you a copy. Where is the record? Record has not yet been received.
I will verify, Lord.
Both
let us verify.
SP border, Dorong SP border, Udalguri, because after bifurcation, record might have gone to the SP border, Udalguri.
Yes, bro.
Yes, Mr. Khan, where is the number?
You've taken steps on 15/3/2024, my lord.
What is the number, filing number?
The website shows, my lord, we have taken steps, my lord.
What is the filing number?
Final number.
This is affidavit of service, my lord. There is no filing because it shows, my lord, the website shows we've taken steps on 15/3/2024.
On what manner? By justice service or by?
No, this is the affidavit of service which we had filed. As regards the service of Dusty, my lord.
What was the order of the court?
Order of the court was to take steps on 9/8/23, my lord,
In what manner?
to Dusty, my lord.
Only through the state or by board?
Dusty, my lord, we have taken steps, my lord.
Okay.
This is the copy of the affidavit.
When did you file this affidavit?
15/3/24.
Look into it later. Yes, we'll take it after some
Yes,
time.
after some time, my lord.
We'll take it up. Okay, no, to
This case, my lord, the petitioner appeared on 3/4/2021.
What about the record?
Record, my lord, what my instruction is that, my lord, they earlier they didn't receive any communication. The reminder they have received tribunal. But my lord, because it is in tribunal number 1, huge numbers of records are there searching for the record in fact. So another 1 week's time they have asking for money. Because it was in all the records were in my lord, tribunal number 1. So everything were distributed from 1. So it has some. So they're paying for another.
Mr. Bank standing for Department or something. Yes, this matter on. Twenty-third of April. Along with the 11 records of.
Obliged.
I appear for the private respondent.
Where is the PSC? Supposed to give us the records.
Well, in this matter, the selection of the APSC was under challenge, and that challenge was rejected by the Honorable Single Judge. And before the appeal was moved, have been appointed. I'm working.
The only ground, the ground of appeal, what Mr. Chaudhary, Ganesh Senior Counsel has submitted on that day is that the interview marks is beyond that the law laid down by the indicator of agency. And that the marks given are not distributed. Showing the advertisements is that the procedure to be adopted, the mark distribution was supposed to be reflected prior to the selection, but it was not done. These are the illegalities shown. Anyway, we're not on that. We want to just see the records and what procedure they have adopted. That's all. Anyway, because this particular matter relates to bench one. And on that day, because Brother Justice Mehdi, who passed the order.
Yes, my lord.
He was there. This concept of justice never came up with.
Please, Your Lordship, very soon.
Mr. Mahanta, wanted to see the records.
Yes, Mr. Doctor is the record is Mr. Doctor and will come back.
May I submit some? May I submit something? Lordship, my senior Mr. K. Chaudhary has conveyed his sincere apology. Lordship couldn't come to court today, Lordship, due to personal difficulty. So I'm praying for adjournment for today, Your Lordship.
Whether records, pass the order. After some time, Mr. Chaudhary.
My lord. My lord, I appear for in the item number 13, 14, and 16. And the matter requires to be heard, my lord, finally.
How much is, what is the I number?
I number 491,
Ah,
madam.
yeah.
491.
Yes, my lord. We have filed the affidavit on 15/3/24, my lord. And it has been served, my lord, duly served.
You have the filing.
I have the copy of the affidavit.
Do you have the filing number?
In affidavit, there is no filing number, my lord. It's just an affidavit. And the website shows that it has been filed on 15/3/24, my lord.
I 491/2020, so item 15 or I. Mr. Escon, counsel for the applicant. Submit. That. Pursuant to the order dated 9/08/2023. The fee of the personal service was made on the responding. Not responding. On the. Yes, and in that regard, has also filed an affidavit on 15/03/2024. However, the same is not available in the case record. We have also seen that by order dated 9/08/2023, the applicant was allowed to take two steps again on the said opposite party number 4. Also by the registered post. And the applicant is yet to take steps in that regard on the side of the party number. This on 4th of April. The minimum applicants will take steps on the respondent. Opposite party number 4 will raise the prosecution on or before. Subject to providing is correct and proper list. Along with the
Our item is item number 14, where we have
all will come on 4th.
4.
Mr. Saikia, you are for which item?
Which has just passed over.
APSC.
APS, ma'am.
Mr. K. N. Chaudhary, there is a prayer on behalf of Mr. K. N. Chaudhary for adjournment of the matter. Will I just like to see the matter, the records?
Lordship.
Pass the order.
Lordship. Because my submission was already over.
Will not do it, but since there is a prayer for adjournment.
Lordship.
I want to see the records. That's all.
Lordship.
Mr. Chaudhary, someone may be here in that matter where you are appearing for the respondent. You can ask someone to be here. Pass the order. Just to see
I
the
appear for
records.
the BTC, Lordship. Hello.
You are appearing for the BTC.
BTC.
Mr. Mahanta was here for the APSC.
APSC.
He submitted that Mr. Doctor is having the record.
Yes.
Just to want to see the
EP,
records and you
Pankaj
pass the
Bhatta.
necessary.
Yes, Lordship. Highly obliged.
Yes, Mr. Do you have a copy of the order? Mr. Pai? Yes. Just want to see the order.
6/2/80/2016.
Just a minute. 6/2/80.
Yes. 2016.
I'll be placing the copy.
Okay, 2018, 3/GLP/5/6.
Paragraph.
2018,
Lordship, I have placed the copy.
3GLT.
3GLT. Yes. 652.
6/5.
मतलब paragraph number 9.
Direction is in para 25. Direction is in para 25.
Direction could be.
Number item should be.
2018. 6
Madam. Madam. By the tribunal saying that the case is filed or closed or whatever. So in that circumstances, the court found that it is the duty of the tribunal when the matter is referred as per the criminal is to give its opinion. So that was the observation made by the court, and the Home Department of the state was directed, in fact, the Register Judicial was directed to communicate that order to the Home Department. Who probably can have, because to inform all the foreigners travel, not only in a particular case, wherever it was filed or kept in the cold storage, the direction was to
Reopen them.
so reopen it by issuing fresh notice. So, because there has to be an opinion. Some on the basis there has to be an opinion on the by the tribunal. In fact, that was an order on the direction was given, register will communicate it to the government accordingly order. That order was passed by the tribunal
14/5.
on 14/5/2000.
And this was reopened on 24/5.
On 20.
Done.
In that case, probably because what we have seen. In fact, initially when this order was passed and stayed this process, yesterday, we found another order. It's a suo motu, in fact, thereafter, it's a late issue again. In 2018, there was a suo motu matter. By the court. In that matter, Mr. Mahanta appeared on behalf of the High Court. And it was a bench consisting of Brother Justice Monojit Bia and Brother Prashanta Kumar Dey. There, the court specifically observed, you can note down the number, WPC suo motu 3/2018. There, the tribunal, the court observed, we hold that mere noting in the note sheet or passing of an order that reference was disposed of without reasoned opinion in the case filed would be no order in the eye of law. Such a noting or order cannot be construed to be an order disposing of a reference case by a foreigners tribunal. There has to be an opinion on record which must carry the seal and signature of the presiding officer of the tribunal. In the absence thereof, such a reference will have to be treated as not being disposed of and be considered as a pending reference, which have to be heard afresh. So here is a case, there are 12 such petitions from Nalbari district. We do not know how many suo motu matters with regard to this pertains to Nalbari district, 12 such matters. And according to direction was given that shall now be heard afresh from the respective stages. The member of the tribunal shall leave the above reference in the notice board of the tribunal giving fresh dates. Fresh notice may also be issued to the proceedings. In the case that was before us yesterday, similar matters from Nalbari, and then fresh notice was given. And that's how there also there was a claim. But ultimately, we found that this order was passed. And the petitioner's case, she's a lady, her case was among those 12. So this is an order passed on 28th of May 2019.
After this case was reopened,
This is
after reopening of my case,
This is
24, 4 days
The
later.
first case is of
First case is 10 days prior.
14th of May 2018,
That is,
which was communicated to the government. Government might have issued all the orders. And here, if you see,
that is what I was trying to, my lord,
no seal of the presiding officer. That's the order. That's the order sheet. Even you have annexed that.
yes.
You have annexed that. That's what we found that. Probably
None of the orders there is a seal. All the other orders have to go then. None of the orders there is a seal.
there is always we found the records. Not
No,
only
even in this one, my lord, in none of the orders there is a seal. The court does not use a seal there.
opinion has not yet been given. No,
My lord.
opinion hasn't been given. The opinion must carry.
As per the enquiry report, OP is on an Indian citizen. Accordingly, the case is dropped.
Look at the opinion. That's what we are saying. That,
This was the opinion. This is
can it
the,
be considered as an opinion?
but when the enquiry report itself says that may be an Indian, what further enquiry can the court hold?
Maybe
Had
an
it been may
Indian
not be an Indian, that's another thing.
may or may not. Who
Does
is
not,
clarifying?
my lord, that is what I'm saying. May it may be an Indian. So it can say, had it been may not, full case for reference, my lord, full trial, no difficulty.
If it is a may, will not be around to suspicion.
My lord,
When there is a may,
the suspicion is on the
When
positive
a-
side.
when a citizenship of a person is doubtful,
My lord, the
May
police
or may
cannot
not.
say I am an Indian citizen. He does not have the authority. Those IOs do not have the authority. He has to say may.
that
He
is-
cannot say is.
what was the police report? What was the
Per the documents submitted by him, he may be an Indian citizen.
then
It ends there.
then what is the observation made by him?
Therefore, it is referred. Could
Therefore,
he have referred? Because
Yeah.
my lord, the law again says that the reference has to be on certain grounds. I doubt the documents. I doubt the parent. I doubt the name. I doubt the age. I doubt anything.
yes,
Where
Mr.
is the
Bhatt,
doubt?
what you have to say?
On procedural lapse, matlab there is a judgment. If it is treated to be a procedural lapse, then there is a judgment saying that
First of all, the Foreigners Act 1946.
And this judgment is getting referred to is a one where the cases were dropped, where the cases were filed because of non-service. Here, mine was applied.
We'll see to that.
It will just prolong litigation. Amount. Yes, it-
it is downloaded from the net internet matter. The next second page matter, if we go 8 line from the below matter. And in the middle part, my lord, it is there. A mere procedural lapse would not give rise to any cause of action to the proceeding. Yeah, that is there. If we treat it to be procedural lapse.
Huh?
He wants to withdraw account number 9. No, he wants to withdraw account number 10. No, he wants to withdraw 10. 10 and 9. He wants to withdraw. Okay.
That case was decided on 3/10/2016.
Yes, Mr. Pai.
My lord, first of all, your lordship may kindly see the what is in the Foreigners Tribunals Order 1964. Order 2 may kindly be seen, my lord. Constitution of Tribunals. The central government may, by order, refer the question as to whether the person is or is not a foreigner. That is the question, my lord. First of all, whether the person is or is not a foreigner within the meaning of Foreigners Act 1946 to the tribunal to be constituted a purpose for its opinion. So two things we have to remember, my lord. First of all, the central government may refer the question to the tribunal for an opinion as to whether the person is a citizen or not a citizen. So two aspects are there, my lord. Whether the person is a citizen or not. Both the question will go. If the reference is sent, the person is seemed to be foreigner, then also reference has to be sent. If there is an opinion that person is not to be citizen, then also, my lord, it will have to go. In both the opinion, for opinion,
Read the order 3.
my lord,
Order 3.
order 3. Therefore, the tribunal shall serve on a person whom the question relates a copy of the main grounds on which he is alleged to be a foreigner and give him a reasonable opportunity to making a representation and producing evidence in support of his case, and thereafter considering such evidence as may be produced, and after hearing such person as may be desired to be heard, the tribunal shall submit its opinion to the officer or authority specified in this behalf in the order of reference. So that is, my lord, the tribunal has to give an opinion after my lord, coming to an my lord, opinion. The tribunal shall serve so cause notice on the person whom the question relates to the proceeding. The notice referred to in subsection so shall serve within 10 days of the receipt of the reference of such question by the central government or by competent authority. The notice shall be served in English and also in the official language of the state, indicating that the burden is on the proceeding to prove that he or he is not a foreigner. So prima facie, my lord, there are two, here is the case, madam. The reference was saying that the person may be a Indian, madam. So it is not that reference is bad. My submission is that, madam, the rule order 2 itself says the reference may be of either whether to make a opinion by the tribunal whether the person is a foreigner or an Indian, madam. Both question. So the question was, my lord, whether it seems to be Indian, whether he's an Indian or not, or whether he was a foreigner or not, that has to be decided by the tribunal by giving an opinion. Now, from the very perusal of the, my lord, the order, the first order.
Yes.
Dated, my lord, 23/3/2017. FT case has been registered under Foreigners Act 1946 against OP said Azharul Islam on being referred the case by DCP Border Guwahati. As per inquiry report, OP is an Indian. Accordingly, the case is dropped. So now, my lord, two things your lordship may kindly see. The DCP has referred the matter to the tribunal. As you, my lord, presuming that the petitioner may be, the proceeding may be an Indian. But to that effect, the tribunal has to give an opinion, whether he is an Indian or not. And that opinion, my lord, should come with reasonable, that opinion should come with, my lord, all what the opinion should contain. And to that effect, the petitioner has to prove before the tribunal by bringing his evidence or her evidence, whatever she has or he has. The procedure is laid down. Once notice is issued, notice should be issued. He should come with reply. He should bring evidence to that effect. Then on the basis of, my lord, I forget. And he has simply, my lord, given order. It's an order, my lord, that the matter is dropped. Following that, there must be opinion.
According to Mazumdar, considering the report of the inquiry officer, so that
Yes.
is his opinion. What do you have to say?
No, that is not an opinion, my lord.
Why?
That's, my lord, what my commission is that, the, my lord, your lordship may kindly see the reference. Reference, my lord, the reference by the SP.
Huh?
Yes. But the reference by the SP, reference before, before the reference, my lord, what is the inquiry report says, during inquiry in prima facie manner, it appears to us that Sayyid Azmal Islam, page 38, my lord, Azmal Islam, daughter of so-and-so, son of so-and-so, may be an Indian national according to the documents submitted by him. May be an Indian national, my lord. Hence, the case may be forwarded to the honorable members FT so-and-so for kind opinion and judgment. That is the, my lord, the observation by the investigation officer. Then, my lord, right below, the as Deputy Commissioner of Police Border has perused the the case records with verification of documents, agree with the opinion of EO's report, that is, my lord, investigation officer. Hence, the case is forwarded to honorable court member FT so for opinion. So this is in consonant with the, my lord, rule order 2 of the Foreigners Tribunal Charter 1964. They have doubt that the person may be an Indian citizen. Prior to this, my lord, there is a doubt by the, probably that is not annexed here, that is in the record, my lord. Prior to this, there was a doubt. My lord, it is in the elsewhere, not here in this petition. In the elsewhere, my lord, first from the Deputy Commissioner of Police, there was a direction to the OC, the investigation officer, doubting that the petitioner proceeding may be a foreigner. Then the EO made an investigation. He doubted. He doubted. He doubted that he may be an Indian. So there are two Malat views. Only not be closed. If there's a money claim, his family will be substituted. If you have a discipline, Muslim, it can be closed. That's good, huh? No, because of, no. You can't find this people, you can't do it. You have to be global again. There are other things. What do you mean? You have to do it. This reference to the community upon the reference to the community of parents. You do any look at the community. What do you think you said? It's a bit important. This story.
Anything else?
My lord, my submission was, my lord, your lordship has seen probably that in the record, the DCP,
Yes.
my lord, my submission is that, my lord, the commissioner of police prior to, my lord, at first doubted that the petitioner is a proceedee is a foreigner, and accordingly he directed the, my lord, the investigation officer for making an inquiry. And an inquiry, the inquiry officer, my lord, doubted that he may be an Indian. So there is contradiction in both the, my lord. So my lord, in EO, that is the inquiry officer himself also said, my lord, in his observation, that it may be sent to the tribunal for an opinion. Thereafter, the DCP border has sent a matter for opinion. So, as per this, my lord, Tribunal Order 1964 rules, the 1964 Tribunal's Order, my lord, there is no my lord, problem in the reference. Reference can be either that whether he is a citizen or whether he is a foreigner. Both the way reference can be made. So the reference was made, my lord, whether he is a citizen or not. Now the tribunal has met an order that is on 23,
3,
yes, 23, 2017,
2017.
dropping the and drop the proceeding. And as per inquiry report, OP is an Indian citizen. That is on the basis of inquiry report of the police. If that is accepted, my lord, in that case, only matters everything where the petitioner is doubted to be foreigner, then he may also accept that the inquiry officer has doubted the person to be foreigner. So he is foreigner. So he can end the entire proceeding in there itself. For that purpose, the proceeding is the reference was not to the sent to the opinion, to the tribunal. It was sent for an opinion. Opinion should consist of the reasoning and the basis and the evidence on the basis of which the tribunal has to give an opinion. There is nothing in this order. This is simply an order. My humble submission is that has there been any separate opinion following this order, it could be a different issue. But there is no separate opinion. But my lord, in every case, either in criminal or civil, we find there is an order. Then subsequent to that final disposal of the order, there is a separate judgment. So here is the case, my lord, here. After 23, 2017 order, there is no separate opinion. Where is the opinion? There is no opinion. So it was sent to him for an opinion only.
Of course. Only the close will go on abatement. The Department of Proceeding has there is being abatement. Department of Proceeding is abated due to the death of the petitioner. And the close will go.
It will be received.
The close will go. Recording the particular. Instructions from the family. Whether they want. Mauricio এখানে মনে প্রত্যেক করবো না এগুলো কোন কথা Mauricio no don't with me we will have it Mr. Pine just take his
Yes.
Não, como nós estamos aqui, vídeo com vídeo. Também faz questão. Vem com uma opinião que eu já vi, sabe? We will speak there in still want to be any custody. अपने आगे लेते हैं. Petu Kesore, 11-1 order. Yes, he was 11 was called 11. Open the Yes, Mr. Pine. Mr. Pine, anything else?
My lord, my submission is that, my lord, that as per rule 3, the opinion, it should give an opinion. The opinion must, before the opinion, there should be evidence of that issue. And on the basis of the opinion evidence, the reasonable opinion can be passed by the tribunal. And this is not an opinion, my lord. 23-3-17 is not an opinion. And accordingly, the tribunal has, my lord, that cannot sustain. The order dated 23. So tribunal has, my lord, after the But the tribunal cannot deny for giving an opinion. While dealing with the issue of res judicata, my lord, whether tribunal can, my lord, do that or not, that issue is discussed. The WPC 7339 2015, my lord.
2015,
my lord. 7339 2015.
what is the finding?
Dear my lord, the para 74 is, in fact, this is, my lord, in case of res judicata, it is said, but the principle, we may take it from this provision, my lord. It naturally follows that foreigner tribunal cannot decline to render an opinion on the ground of res judicata. So, suppose a person comes before the tribunal on the ground of res judicata, then he cannot decline that it is a res judicata, so I cannot pass an opinion. Similar is the case. If the, my lord, reference is made to him, he cannot deny to give an opinion. And this order is not an opinion, man. If a previous opinion favored to the proceeding in place before the foreigners tribunal by a proceeding, foreigner tribunal will consider the same and thereafter render its opinion. If the subsequent opinion is adverse to the proceeding and is silenced by proceeding under 226 of the Constitution of India, then the High Court will consider both the opinion while examining the correctness of the letter. Its silence would have to be decided on the case-to-case basis. So that was in case of, my lord, res judicata. But here, my lord, it's like res judicata only because he has dropped the matter. Then again, it is reopened. And while dropping, there is no opinion and there is no reason of that.
Can you give us any, can you place any such communication from the Home Department after the order passed by the court reported in the 2018 3GLT 652. Definitely, otherwise the tribunal
Yes,
would not have reopened the matter. Was there any direction from the Home Department pursuant to this order of the court passed on 14/5? Will you able to give it to us by 27, 20?
let me check it out, my lord. There may be a communication.
Give it to us,
Yes,
and if it is available, we'll fix it on 28 in that case.
May I just point out one thing? The issue here is not whether this particular opinion will become binding either on the proceeding or on the government. The issue here is, could it have been done in a manner in which it has been done? A fresh reference, a fresh doubt, nothing is barred in law. Nothing is barred in law. We are only before this honorable court to see whether a right thing has been done in a wrong way or a wrong thing has been done in the right way. Any wrong done in the right manner will be upheld by this court, but any right done in the wrong manner cannot be upheld by this court. That was the entire
But Mr.
basis of the
Mazumdar,
case. Nothing else.
being a court officer, also try to find out.
Yes,
There is a judgment of the apex court when the matters are exercised by the quasi judicial tribunal.
my lord.
The court, while exercising the jurisdiction, has to take up the matters only when the final order is passed by such tribunal. Till such the matter is in the interlocutory stage, whether the court should interfere or not in exercising the jurisdiction, because you just find out there are judgments.
That can be, my lord, that I can even produce today itself. I'll have it. Court says that interlocutory stage, there should be no interference except on three grounds. One, it is done without power. One, it
Do
is
you have
done.
the citation
Two,
with you?
it is, I'll give it exactly right of now. I don't have it. I produce it in another court. Two, when it is with mala fide, is proved or can be apprehended. And three, when there is no cause of action at all. This would fall in the first stage itself. It did not have the power.
No, that is why we have asked Mr. Payeng whether after this order of
And
the court.
Lordship, one thing needs to be noticed on this order of 2018 3 GLT 652. One thing needs to be noticed. Lordship will find, it says at para 9, this court has already held that when a reference is made by the referral authority to a foreigners tribunal seeking its opinion whether the proceeding is a foreigner or not, question of filing such a reference on the ground of non-availability of the proceeding or non-service of notice does not arise. The entire issue was when the proceeding cannot be traced,
Truly.
he died, this happened,
That is
that happened.
That is the difference.
And Supreme Court is very clear on this. A judgment will relate only to the facts which is decided.
See,
Interpreting judgments
that is why
in the manner sought to be done by my learned friend now. One, two, he brings in the case of res judicata. I admitted position, my lord. A fresh reference, I will have to face it. Should this be reopened is the only issue.
whether this is an opinion or not, first of all, we'll decide.
Whether it was
Secondly-
whether if he could have so much reviewed it at all is what
Secondly,
lordship will
whether it
decide.
was done on the basis of the order doesn't reflect, of course, but thing is whether it was communicated. In fact, that can be always placed by Mr. Payeng from the
Yes.
office of the Foreigners Tribunal. And secondly,
In my challenge to an order which reopens the thing, the state takes up a challenge that the original order is wrong. They never came before this honorable court to say that our order was wrong. It is not an opinion. Kindly have it reopened. They slept over the matter.
we'll decide.
They did not come over it. They did not give a fresh reference. Nothing done.
We'll look into it.
They had so many options. They could have challenged that order. It is not that it is not in their knowledge.
We'll-
That letter must have gone to them. They know.
We don't know.
When you ask for a reference and the case is dropped or closed or whatever is done, that letter goes to them. They sleep over it.
Whether it was communicated to you.
To me, yes, that is how that is why I am before this court.
Is it?
That is why I am before this court.
It was.
That it was dropped once. On their documents, it was dropped once. Why am I here?
How you are aware
Of
that order of 23rd?
Para 10, my lord. Diligent persons, they pursue. What happens? These are orders of for tribunal. Deemed to be in public notice. Deemed to be in the notice of the person against whom an order is passed or in favor of whom an order is passed. Zeal to see that a doubtful person doesn't escape. Cannot be that we will give all procedure of law, my lord, to the guilty. The arguments made, my lord, there are arguments which do not have an answer, cannot have an answer. It's beyond answers. When the judicata is brought in on this type of a case, when the judicata is argued, when it is argued that filed or so-in cases are required to be reopened, which are not the facts in this case. That is why it is time consuming. Irrelevant materials placed. Particular question, does they have the power? It is a yes or it is a no. Even an opinion, when it does not get the support of res judicata, whether this is an opinion or not an opinion, my lord, that in my humble submission, that need not be an issue. Once a person is declared to be an Indian, fresh reference of fresh proceeding starts. Whether this is an opinion or how does it matter? Whether it should have been afresh or whether this can be reopened. That is the only issue.
What does the order 2 and 3 says of the 1964 order?
I missed the case today.
Whether
Actually, I
it
don't
is
even have my
order
books with
to-
me.
Whether it is an opinion and just a pending of the trial.
Well, the only thing that one thing lordship will
What is
also
the role of the extrajudicial authority like this?
order.
2 and order 3.
I got that. The tribunal shall consider when the tribunal has 2 members, it can be so and so. So see, the tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be a foreigner. Main grounds. And give him a reasonable opportunity of making a representation and producing evidence in support of his case. And the ground is, you have documents to show that you may be an Indian. That ground will be served upon me. And give him a reasonable opportunity of making a representation that I already have given the documents. And producing evidence in support of his case that this is the voter list. And after considering such evidence as may be produced and after hearing such person, the tribunal shall submit its opinion to the officer authority specified in this behalf in the order of reference. The authority in this particular case already says he may be an Indian. The foreign tribunal shall serve a so-called notice on the person to whom the question relates. That is the proceeding. The notice referring the so-and-so shall be served within 10 days of the receipt of the reference and shall of such question by the central or competent authority.
Yes,
The-
Mr. Pai, let us see if there is anything.
Yes.
We'll
My lord, may
consider
kindly then
29.
read, my lord, the from para 6, the
Which
rule
one?
6 onwards, my lord.
Which one?
In the same, my lord.
Huh?
After 3, your lordship may
No.
kindly see from reads
Yes, we know. We have
6.
discussed all those provisions in
Yes,
another
yes,
order.
my lord.
Come to 6.
6, 7, 8, 9, 10, everything is there, my lord.
These matters have been discussed in the full bench,
Yes, my lord.
right?
Yes.
The
And
court also
the-
says that the review would not be permissible without an application.
And
If I understood it correctly.
Not in disturbance, another.
that is in different case, my lord. And the procedure of foreigners tribunal will be, my lord, made by the foreigner tribunal themselves. There is no procedure laid down. It is
Will,
the foreigners tribunal who will make their own rules, procedure.
Just show us that communication of the Home Department after the order of the tribunal.
Yes, let me check it out.
APSC, where is Mr. Doctor?
20.
Lordship is fixing it on a particular date.
28.
28. कहीं बाहर तो नहीं है?
Doesn't it?
बाहर तो नहीं लिखे।
Timing item number 12.
28. Oh, 20. Well, could it be on this second, my lord? I may not be here on the last week. Otherwise, let it be 20th. No, no difficulty. Let it be.
If you are absent, ask your colleague to make a mention to consider.
My lord. Obligation.
Lordship, the record I have produced consists of three part, Lordship. Lordship, that record, Lordship, consists of three part, Lordship. One, Lordship, is the API self-assessment sheet of both the candidates on the basis of assessment was done by expert. That is in Lordship sky blue envelope. That's the envelope, Lordship.
Take your seats. Mr. Datta, we have not opened the seal covers.
Lordship,
Let it be sealed.
Lordship.
Just gone to the record. It's 1 more minute. Kumoy pala din. Pursuant to our observation. During the deliberation, the matter on 18/03/2024. Mr. PP Datta. Mr. Mahanta, you live here? Mr. TJ Mahanta. Learned Senior Counsel. For the respondent APSC assisted by Mr. PP Datta. Learned. Standing counsel. He placed the relevant records pertaining to the selection of principal of Pokrajhar Government College, Science College, right?
Government College.
Pokrajhar Government College. For which selection was held on 5th of November. 5th of November 2022. However, Mr. K. N. Chaudhary, Learned Senior Counsel, appearing for the appellant. Could not appear before the court today for his personal problem. An adjournment in the matter has been sought for. To the learned counsels for the respondents have no objection. Prayer allowed. Third of April. Records have something interesting.
No, my lord, your lordship kindly should not overcome that order that is 11/10/2023. That is very important that your lordship kindly see that order, kindly see my lord, your order. That already that order, entire record has been produced by earlier, 11/10/2023.
Or that the affidavit.
Because your lordship kindly says that affidavit, my lord, actually what happened in this case?
No, we're not passing any such order. We're not intervening in any merit of the case at this stage.
My lord.
The matter will come on 3rd of April.
My lord.
No, that's wanted to peruse the records.
My lord.
Because some allegations were made regarding two of the
Yes,
members of the selection board.
My lord.
and the distribution of marks.
Okay, my lord.
But something else have propped up in the records.
Okay.
But it is found that the allegation against those two members
Okay.
for which there was a allegation that those two
We are privy to the academic record.
members have already perused the documents of the petitioner, the appellant, as well as the respondent.
My lord.
But the records clearly reveals that they were called earlier only for a discussion regarding the
My
process
lord.
of selection of principal.
That's why I'm pointing out disorder, my lord,
Because
because
that is
this type of,
the record itself reveals.
Yes, yes.
Very specifically, the note sheet and everything
my
reveals.
lord.
When the communication made to those two principals, also very clear that only for the purpose of discussion, there was question of record was not there at this stage,
My lord.
even if the mark sheets or whatever. Ultimately, during there was an corrigendum. Again, the applications were sought for, ultimately shortlisted the two candidates. They appeared. And on the day of the interview, the documents were placed and two persons from the commission have verified those documents
My lord.
and their reports are very specific. That is very interesting.
That's why, my
It is
lord.
not the principal of the college, of
Yes.
the colleges
Okay, that's
have
why, I'm-
examined the documents.
why I'm
The
here
two
because
persons that for you from the records you have seen.
no, I'm just submitting one thing before your lordship. My lord, we tried to, my lord, clean up this matter, have to clean up the APSC and now everything is in clean up. Is somebody, my lord, your lordship, that's why it is very important, my lord. I will not, my lord, they will not go to, because it is
Sometimes,
judicial
you know-
order. No, your lordship kindly see, that my lord, how it is bad to him also, my lord. How he can verify that it is, it is true, my lord, because advocate also, my lord, will be in trouble, my lord. Because without going to the original record, how he can certify to be true?
See,
Your
definitely,
lordship kindly,
Mr.
that's why my lord, the court has taken very seriously, my lord.
that
That's why
you
if it is
insist-
wrong in our part, we'll clear it. But if it is wrong or Sangistan, my lord, try to blame someone, that will not be,
Mr.
will not be allowed, my lord.
Mr. Mahanta, place it before the next bench, wherever it is comes on the next date, right? Because that affidavit has not yet been filed, which you have seen from the record. So secondly, that order still remains still valid.
My lord,
And then records reveal
no,
something else.
my
That
lord.
is what we have been now found. But anyway, that the appropriate bench will consider, right? Just the record placed before the court to take by the APSC regarding the said selection has been returned to Mr. P.P. Dutta, Standing Council, APSC, which shall be placed again before the court on the next date fixed when the matters are taken up.
Okay, let the matter may be taken on 2nd of April instead of 3rd April.
Third April, some other matter.
On second. Mr. Mahanta. Mr. Gogoi, Mr. Datta. See, sometimes what we have seen during this kind of selection, necessarily there will be some persons in the concerned office.
I tried to find it out who is he. No, that's actually, my lord, for
When,
betterment
you
of the
see,
society, my lord.
Even we try our best
No, my lord,
to maintain the secrecy regarding the selection.
even
And
sometimes,
I'm proud because our registry, in fact, keeping that secrecy to the highest extent.
exactly, my lord.
Even our brothers are not aware. Whoever in the selection committee, what happened, our brothers are not aware. Nobody will know.
Yes.
In fact, on that day, we have been telling us that while we are in selection, even we do not know
The marks.
the marks the candidates they secured during their written examination.
That's why, my lord,
Only we give the written the marks in the oral interview.
Lordship, in this case
Only
also,
when the results are declared, because everything is in the website, everything, whichever the concerned board, number 1, 2, 3, there will be 3 members in the selection or 2 members in the selection. The marks given by each of the members of the board, we see. Then only, even we do not know what our brothers are giving or sister is.
yes,
right?
exactly, my lord.
And that's why I'm saying that our registry is maintaining to that extent. And we are really proud
Yes,
that
yes.
they are, that's why hardly you will see any matters
Yes. Regarding,
regarding the selection process of the High Court. There may be some process where their marks had been given less or some marks not been deducted. Normally, as to the highest level, the secrecy is meant to be the highest authority, and that is why sometimes brothers and sisters ask me how he has been selected, what happened. We thought this man will be selected. No, things are there because everything is in the website. Clearly, marks given by
yes,
the marks secured during written examination, marks given by the author. We are not even aware.
even my,
on last occasion, Lordship has posed a query that how this mark of academic was made to available to other members. I have taken instruction back. While sitting in the interview board, none of the members is aware about the academic marks of the.
No, normally what happens, the marks, normally what we have seen in earlier process, that APC or whatever you say, that is
API.
API marks. API marks have to be counted by the
Candidate himself.
Person concerned.
himself or herself.
Self-assessment.
So self-assessment.
So that is, yes, that is their self-assessment, yes.
So necessarily the candidate will know what will be the marks in the
Yes.
the she is or he is likely to get during in the considering her or his academic qualification. That can be, that is certain.
And
But for the candidate, other candidate, the petitioner or the incumbent may not be aware. The thing is with regard to himself or herself, they're aware.
in Lordship, UGC regulation and the statement of API Lordship which I have supplied, I have also gone through. There is no mention about the marks obtained in the SSLC, ACS degree, even only the PhD component is there, and the research publication they have made, that is only there. Even the academic mark was not in the API. The allegation there has been raised that the 2 members is aware of the mark.
No, that's what particularly we were going through it, found that it was only for the purpose of
Yes.
discussion of this selection
Yes.
process of a principal.
Yes, Lordship.
No.
How the process of
Yes.
selection, because
Yes.
only that discussion, the letter itself,
Yes,
My
yes.
only for the discussion, there was no question of going through the
No.
these whatever the applications they submitted.
My
It
lord.
was not before them.
No,
We have seen both
actually,
the order sheet as well as the note sheet as well as the communication made.
actually, we try to keep it, my lord, everything transparency. Even this time, my lord, ACS, my lord, there is a carbon paper, carbon sheet in, my lord, AOMI sheet, my lord, they will take away, very same day, they will take away. So that's why, my lord, it will, just to keep the transparency. OMR sheet along with carbon, they can take away.
Which was they have answered, they can go on.
Whatever the answer he has given, the candidate has given, they will know. So at least one copy will be, the carbon copy, they can take. But this time it has been applicable.
If you are cleaning.
So,
Some of our
yes, last time, my lord, one of the, I have heard that one of the, our employees, but they are doing very well.
Even 2 are selected from our register.
yes, protocol officers
Yes.
selected in
You are
the
No, within 10, my point, within 10. So that's why, my lord, we try to, if there is any shortfall in our part, my lord, your lordship kindly point it out, we try to remove it.
But if any member has divulged some
Then, my lord,
paper, force paper to the senior advocate, it is unfortunate Lordship to the system.
we
deeply.
will not comment on that.
Excuse me, my lord. I have given the written argument.
Oh, yes. It will, okay. Mr. Mahmood, have you given the date?
Yes, the last page.
No, date you have given?
Yes.
To make it, you filed it through someone. Initial, whatever.
Lopez.
There should be a signature in each and every page.
Actually, okay.
We have filed for correction of the
Your Lordship, can it be after 10, to your Lordship? Can it be after 10?
Because of Punjab.
Okay.
I-20. No, maybe.
May it please your lordship. Lordship, in this case, the petitioner has been declared as a foreigner lordship. The opinion lordship will find on page 42 lordship. Lordship.
My lords, item number 5, my lords. Next week, my lord.
May it please your lordship. Lordship, in this case, petitioner has been declared as a foreigner by the Foreigners Tribunal, page puts 7. That opinion lordship will find on page 42 lordship. Link document, Lordship, school certificate, that is on page 25, Lordship. Lordship thinks is that otherwise she has all the document, but the Lordship, without proper advice, Lordship, she has not proved those document, Lordship. Now, Lordship, may I pray, Lordship, one opportunity may be given to prove those documents, Lordship, prove those documents which are exhibited at that time of Lordship. That Lordship, only things is that only the document has to be proved, Lordship. Lordship, that time, Lordship, it was, she was not properly guided, Lordship, that's why, otherwise, Lordship, her father's read petition, Lordship, remand it back for Lordship. Lordship, kindly come to page 9, Lordship. Paragraph number, line number, Lordship, 1, 2, 3, 4, 5. 5, Lordship, may I read, Lordship? The petitioner has not proved the content of the school certificate and link marriage certificate, being ignorant of the process of law, also being not properly advised by either by her engaged counsel or by the learned foreigners tribunal. Now, Lordship thinks that now, Lordship, only I may allow to prove those documents, Lordship, which I exhibit before the tribunal, Lordship. Only that part, Lordship, I need, Lordship, that matter should be remanded back, Lordship. Only that opportunity, if fail, Lordship. Only, Lordship, for the interest of justice, Lordship, for the interest of the other. Otherwise, Lordship, fathers. Yes, Lordship. Yes, Lordship. Yes, Lord. Yes, Lord. Lordship, then I need some time, Lordship, because Lordship, in one case, Lordship, Hamida Bibi, Lordship, Hamida Bibi versus coordinate bench, that Lordship, coordinate bench has allowed the. Yes, Lordship. Right now, Lordship, that's why Lordship needs. Yes. Lordship thinks is that, Lordship, the brief which I received from the council, Lordship, he has expired, Lordship. Now I have no communication with the client also, Lordship. That's why on the last day, Lordship, has made a prayer, Lordship, give me some accommodation because I have to contact the client, Lordship, through messenger, Lordship. Only the otherwise document is there, Lordship. Document is there, link. Yes, Lordship. That is the Lordship, that is the lacuna on the part of this petitioner, Lordship. She could not prove that, Lordship, because of that advice, Lordship. She has exhibited all the document, Lordship. Lordship, school certificate, Lordship. It's obtained, Lordship, 11/9/2013, Lordship. Page 25, Lordship. That school name is, Lordship, leave, Lordship, it is 1972, Lordship. 72. December, Lordship, December 31st, Lordship. Lordship, after that, Lordship, Lordship, certificate as well, the date mentioned in this certificate, Lordship, it is 11/9/2013, Lordship. Almost, Lordship, 10 years, Lordship. 11 years, Lordship. Yes. Pardon, Lordship? Yes, Lordship. Then it will be, Lordship, 41 years, Lordship. If I not made a mistake, Lordship, 1972 to 72, 2072 to 2000 is for. Yes, Lordship, 73, Lordship, then it's 40 years, Lordship. Yes, Lordship, 73, 2070, 1972, 3. Yes, Lordship. Yes, Lordship. No, 27. What? Yeah. Yes, but Lordship. Yes, Lordship, it's if I not miss. 41. 40, I said Lordship, 42 years, Lordship. Yes, Lord. Now, Lordship. That can be possible only by calling the witness. Is no, that is not there, not there. Lordship. That can be proved by calling the record of the. Yes. Yes, Lordship. Yes, Lordship. Yes, Lordship. I have. Otherwise, Lordship, the father's registration, Lordship, is an old document, Lordship. Father's name is there, Lordship. Link, Lordship, Lordship, Aadhaar card and Gaonbura's school certificate, that is, Lordship, not proved. Gaonbura certificate is there, Lordship. That was not also proved, Lordship. Only part that she was not advised to prove that. Only exhibit, Lordship. Otherwise, Lordship, in the voter list, her name is appearing in page 31, Lordship. First time after marriage, Lordship, her name is appear, Lordship. That is on 1985, at the age of 22 years. Exhibit, Lordship, school certificate on page 25, Lordship. It is exhibit 1, Lordship. Lordship, that time, Lordship, on 13, it's 49 years, 5 months, 17 days, Lordship. On 11/9/2013, Lordship, we counted 11/9/2013. As per his school certificate, that time her age was 49 years. But that it will be, Lordship. (1664) 1964, Lordship. Because, Lordship, on 72, her age was 49 years. 1972, her age was 49 years. As per certificate, Lordship, page 25, Lordship. Bidyaloy Porisil, 1972, December 31st, Lord. And then lordship, that time on 2049 years, 5 months, 17 days. So if we deduct lordship 49 years from the 72 lordship, sorry, lordship, from 2013 lordship. If we deduct that lordship, 49 along with this. Two 2013. It will be 1964 lordship. Lordship, Lordship, her name appear in the first voter list that is on page 31, 1985. Yes, Lordship. 85, Lordship, page 1980, page 31, Lordship. 1985, Lordship, date of voter. Exhibit, Lordship, it is exhibit 9, Lordship, page 31. It's a certified copy, Lordship. Yes, Lordship, it is a record is there, Lordship. 1985 voter list, it is exhibit number 9, Lordship. Date of exhibit, Lordship, 29/8/2018. But judgment, Lordship. Yes, Lordship, in the judgment, Lordship, page 47, Lordship, it is there, Lordship. Bottom paragraph, Lordship.
Yes. 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 My lord.
At first, petitioner here in this petition lordship relies on the document annexure 1, certificate of registration lordship. Which was issued in the year 1969 lordship as per petitioner's contention lordship. At that time, father of the petitioner was aged about 41 years. Then lordship, the petitioners then rely on the NRC document lordship, which was prepared on the basis of voter year 1961. But here in this petition lordship, there is no voter list of 1961 and yes. Here lordship NRC document was prepared on the basis of voter year 1961. At that time, lordship, in the year of 1961, petitioner, father of the projected father of the petitioner was 45 years of age, lordship. But lordship, there is no voter list of 1961 annexed in this writ petition, never placed before the tribunal, lordship, by the proceeding in respect of her father, lordship. Then, lordship, apart from that, after this NRC document, petitioner relies on the voter list of page 22 of her projected father in the year 1993, lordship. In between, voter lists are not there, lordship. So, lordship, petitioner could not able to prove his her father's existence, continuous existence in the Indian soil, lordship, prior to 1966, lordship. And lordship, voter list relied by the petitioners are not certified copy. 1993 voter list, lordship, is not a certified copy, lordship, and that cannot be accepted as valid piece of evidence. Then lordship, school certificate, lordship. Timothy Bafanti
Certificate copy, page 35. 1993 voter list, certificate copy, page 35.
Lordship, then page 25 to page 25, lordship. This is school certificate, lordship, which is not a lordship admissible evidence, because lordship, due to state emblem was embossed at the top of this certificate, lordship. Regarding that, lordship, apart from that, lordship, after death certificate was issued after 41 years after she left the school, lordship. Regarding that, lordship, I want to rely on a decision of this honorable court, lordship. WBC 7756/2016. Kuteja Khatun versus Union of India, lordship. 7756 of 2016. of 2016. Yes, lordship. Wherein para 12, lordship, it was clearly stated, lordship, may I read, lordship, para 12. Exhibit AJ transfer certificate dated 9/1/2016 issued by the headmaster of Uttar Durabanti Bill LP School, certifying that Masammat Kudeja Khatun was the daughter of late Jonna Bali of Durabanti Bill village under Moirabari police station in the district of Morigao. She had left the school on 31/12/1988 after passing class 2. As per admission register, her date of birth was 12/1/1981. This certificate cannot be accepted as a valid piece of evidence for more than one reason. Firstly, the state emblem of India embossed in the certificate. The state emblem of India Regulation of Use Rules 2007 has been framed by the central government in exercise of powers conferred by the Section 11 of the State Emblem of India Prohibition of Improper Use Act 2005. This act was enacted by the Parliament to prohibit improper use of state emblem of India. Section 3 specifically prohibits improper use of state emblem. It says that notwithstanding anything contained in any other law for the time being in force, no person shall use the emblem or any colorable imitation thereof in any manner which tends to create an impression that it relates to the government or that it is an official document of the central government or the state government without the previous permission or authorization. Headmaster of LP school is not authorized to use the state emblem in India in any manner. Thus, unauthenticated use of state emblem in India has rendered Exhibit A inadmissible in evidence. Secondly, as per this certificate, petitioner had left the school on 31/12/1988. This certificate was issued 28 years thereafter on 9/1/2016. Such belated issuance would necessarily cast serious aspersion on the bona fides of such certificate, which is heightened by the unauthorized use of state emblem of India, that too not as per the statutory format. Thirdly, and most importantly, the author of the said certificate did not appear before the tribunal along with the school admission register to prove the contents of the said certificate, more particularly date of birth and relation with late Jonna Bali. How the date of birth in school certificate has to be proved has been settled by the Supreme Court long back in Viratmal Singhi versus Anand Purohit, reported in 1988 supplementary SCC 604, and further reiteration is not necessary. Therefore, Exhibit A, besides not been proved, is also inadmissible in evidence. Lordship. So, Lordships, as per this decision, Lordship, school certificate procedure at present could not rely on the school certificate at this stage, Lordship, to prove his case, Lordship. Then, Lordship, Gaubura certificate, same thing has been given, Lordship. Here also state emblem is used by the Gaubura, Lordship. Unauthorized use of state emblem in the certificate makes that certificate inadmissible in evidence, Lordship. Again, Lordship, there are also so many decisions in respect of Gaubura certificate, Lordship. If required, Lordship, I will provide, Lordship. Again, Lordship, this Gao Panchat certificate, Lordship, they rely on Gao Panchat certificate. Yes, Lordship. Government of Assam was embossed. Regarding that, Lordship, 6344 of 2016 WBC 6344 2016 Rukia Begum versus Union of India. Yes, Prof. Yes, Prof. 93 also photos.
No,
93.
93 certificate copy on page 35. 93 certificate copy. Page 35.
Lordship, this is in respect of her Lordship. I am saying about her father's photo list, page 22. That was perhaps not exhibited, Lordship.
Father, 93, but that was not certified.
Yes, sir.
Yes, Lordship. Father one was not certified copy, but it was exhibited, Lordship. Page 23.
Lordship. Regarding Lordship, Gaon Panchayat certificate, I am wrongly cited this judgment, Lordship. This will be 7756 of 2016. Government of Assam was embossed in the top of the certificate, Lordship. Yes, Lordship, 7756 of 2016. Kudeja Khatun, Lordship. Para 15.1, Lordship. Lordship. Decided on 26/4/2018. Lordship. May I read, Lordship? Exhibit D is a certificate dated 15/6/2015. Yes, Lordship. Yes, Lordship. Exhibit D is a certificate dated 15/6/2015 issued by the Secretary Gorobari Gaon Panchayat certifying that Kudeja Khatun was the daughter of Juna Bali. At the top of the certificate, Government of Assam was prominently printed. It was also mentioned in the certificate that same was issued on the basis of evidence placed before the Secretary. Firstly, this document does not appear to be a genuine document in as much as Gaon Panchayat is not a department of Government of Assam. Therefore, Gaon Panchayat is not authorized to use a letterhead with Government of Assam printed therein. Secondly, the Secretary of the Gaon Panchayat did not testify before the tribunal along with the evidence on the basis of which Exhibit D certificate was issued to prove the certificate as well as the contents thereof. Therefore, this certificate was not proved. Thirdly, Supreme Court has clarified in Rupajan Begum versus Union of India reported in 2018 1 SCC 579 that such certificate of Gaon Panchayat Secretary is by no means of proof of citizenship. Such a certificate has to be verified at two stages. At the first stage, authenticity of the certificate itself is required to be verified to find out as to whether it is genuine or not. The second stage of verification relates to verification of the contents. There is nothing on record to show that Exhibit D had undergone any such verification exercise. Therefore, Exhibit D cannot be accepted as a valid piece of evidence. Lord. Yes. Then, and in this case, Lordship, apparently proceeding. Yes, yes, Lordship. Yes, Lordship. Yes, Lordship. Apparently, Lordship, here in this case, Lordship petitioner proceed could not able to prove his link with his projected father who is continuously residing in the state of in Indian soil, Lordship, from 1966, Lordship. No, Lordship. No.
Expert, Father, proceeding expert, Lordship. No, Lordship, that's why, Lordship. In evidence, Lordship, in No, Lordship, it is not stated, Lordship. Yes, Lordship. Page 27, Lordship, Gambura certificate is Gambura certificate exhibited, Lordship. Page 27, Lordship, it is the exhibit number 4, Lordship. Digendo Chanda Mondol, late. Exhibit 4, Lordship. Gamura certificate, Lordship. Page 27, Lordship. Kindly peruse page 27, Lordship. Page 27, Lordship. Lordship, the evidence copy I don't have, Lordship. Then lordship. Exhibit 4 lordship, it is submitted on 29/8/18 lordship. Page 27 in my read petition lordship.
Yes. Exhibit 1 is the school certificate. Exhibit 2 is the certificate of registration. There is an exhibit document. Exhibit 4 is the legacy data, NRC document. Exhibit 5 is the land document. Exhibit 6 is the marriage certificate. Exhibit 7 is the certificate copy of voter list. Exhibit
Government jet certificate. Judgment of this.
Gravura certificate is not exhibited. Yes. Yes, yes, Lord. Yes.
Lordship, my humble submission gave me, let this petitioner be given one opportunity to lordship. That- Right, no lordship, that is available at the
Lord. Yes, Lord. Two 2023 SCC online. SC. 2023 SCC online. SC 996.
Yes, lordship.
ST 996. 996.
Yes, lordship. 28, can it be on 28? This is 27, lordship. I have another. No, lordship. 20. 28. Hello.
Oh, no. Oh. There are one piece. Yes. Key.
Bill.
After that. Offense for my 26 Main allegation is against Jamaluddin Lordship. And already now charge sheet is submitted and petitioners will appear before the trial court and cooperate in the trial Lordship. बाकी जो अरेस्ट है यहाँ पे appear Application appears to total amount of
Trustee Pires, any question? Okay, here you go. What are the rest of small?
Yes,
Hello.
the results are very clear. Okay,
Money.
Victim lordship that he survived, lordship. That subsequently charge sheet was submitted only under section 326 and 307. Arms Act is not there, lordship.
Sharp weapon, my lord, as per injury report. And vital part of the body, neck injury. my lord.
At this
Let them
stage,
surrender before the my lord, plant could be. Let them surrender, my lord.
I will be allowed 10 days protection, lordship, then in the meantime, he will appear and apply for regular bail, lordship. Because already charge sheet is submitted and putting them behind the bar, lordship, investigation will not help, lordship, because already they completed it. And if anything, any material is there, they will face the consequence, lordship. And in support of my submission also, I have already submitted before, lordship, that Amanpreet Singh's case, lordship, the Honorable Appellate Court also said that I'm only paying for 10 days protection, I will appear because that case is at committal stage. And committal court cannot grant me. So at this committal period, lordship, I am paying for bill, lordship.
As far as your report, and the victim was referred to Silchar Medical College.
That I have placed before Lordship. A separate page was given, Lordship. Only of Lordship Faziruddin, petitioner number 2. No, Aziruddin was not rejected, Lordship. He came first time before this one.
Well, perhaps the case is not committed as yet. The records are in the court of magistrate. So he has to surrender before the learned magistrate. Someone is issued by magistrate, huh?
But if I go there, I will be put behind the bar. So therefore, I'm
That is
paying
different aspect.
Therefore, I'm paying lordship that 10 days time may be granted. I have given
No,
one
even if he appears before
order
the
of
learned
lordship
session
that
judge, who the learned session judge will pass the order.
one
Records
coordinate
are
bench
not-
judgment I have given lordship, may kindly pay with that lordship, that Guria Begum lordship. In that case also, they were, that, no, the coordinate bench lordship. That 207 is elaborately discussed because of 207 is there. And the magistrate has a limited jurisdiction to grant bail in sessions payable case. There is bar under section 437 lordship in granting the sessions payable. In that case, bail was granted, but I am paying only for till time or till committal process is done, lordship, for 10 days. I have given him a copy, lord.
That order can be passed, but one clear direction should be given without that the learned magistrate, when he will pay for regular bail, without being influenced by this, or his bail, prayer for bail, regular bail will be considered.
The trial court will consider for committal period.
Not trial court, the committal court, the case is not committed as yet. Someone has been issued by the committal court. Records are with the committal court only.
For 10 days, they will be protected, Lordship.
Always.
May I please your lordship? This case, your lordship. Lordship. Which says your lordship, bail is exception, jail is a rule, your lordship. No, your lordship, now latest.
2024.
It says in
I
UAP
have-
cases, bail is,
Gurvinder Singh.
bail is, jail is rule, bail is exception. your lordship. Very recent. rule. Jail is rule, bail is exception.
So far UAP Act.
So far UAP. is-
Gurvinder Singh.
Lordship. 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 Lordship.
2024. One SCR.
Your lordship, SCC online,
No, SCR. Law life.
live law, your lordship.
Live law.
Lordship. Lordship. Lordship.
Criminal appeal.
303, your lordship.
Give me an appeal number, my lord.
Two 2024.
Decided on
19th January.
19 January.
Lordship, party's name. Same then. Lordship. Lordship.
Yes.
Lordship.
Yes, should be. Yes.
Lordship.
Pertaining to that particular case. Yes. That is. Exactly.
Lordship. In criminal petition, your lordship. Lordship. Stay ordered.
Stay ordered. Yes.
Lordship, lordship.
Yes. Hmm.
Lordship, ultimately this court will have to be taken by, and if other cases, your lordship will have to be tagged with this.
My lord. Yes.
Oh. Lords.
My lord.
Yes, Lords,
Yes.
this should not happen.
In administrative side. Hmm. Yes.
Lords.
Hmm. My lord. If I could.
Lords. Lords.
And when,
Lords.
yes, well, normally, courts believe the lawyers. Being a member of, the noble profession. Yes. Yes, yes. And your lordships know, in our days, we were trained by our seniors, don't tell a lie before the court. That was, we were trained like that, my lord.
How does this, the people is to ignore this fact?
So,
The young lawyer.
yes.
Okay, so this is the.
Lords.
That is probably.
Yeah.
Because I don't separate those, they also to be considered by.
Lordship, probably your lordship, these all matters will have to be taken up by your lordship. If you going by the, since, lords, 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 yes.
Hmm.
So. Somewhere, we wanted to have this. I was preparing a conversation.
Lord, Lord.
Yes.
But due to some reason, the record.
That is why yesterday, actually, I made this assessment there. April.
Lords, Lords.
23rd of April, after Bihu vacation.
Before Bihu vacation, your lordship.
Then 9th of April. 9th, this is.
Lords. Lords. In the meanwhile, your lordship.
Yes.
After going through the judgment, your lordship.
Yeah, thereafter, that order will be
If
passed.
necessary, your lordship will file an application before the registry.
Lords. Look, Lords. Lords. Lords, my lord.